rights of people who've been convicted but have served their sentences. So I was actually a little surprised at that outcome, but there you go. Of course, there was also a ballot initiative related to criminal law here in Kentucky, and Marzy's law, as it has come to known, passed. But now the question will be, should those votes be certified? Because Judge Wingate in Frankfurt struck it down, said it was an invalid proposition, and that will have to be decided by the state Supreme Court. Had it not passed, then it would be moot, and the state Supreme Court wouldn't have had to decide it. But since it passed, it'll be up to the Supreme Court to decide whether it was valid in the first place.
So, in regards to Marzy's law, I have questions about requirements of language on ballots, because the way that it was put on the ballot, it seems intuitive. It seems like everybody would want that, but it doesn't really tell the whole story. So, like, are there requirements for?
Well, that's what Judge Wingate said. He said it was not. It's too vague. It was misleading because of several reasons. One of which was that it didn't go into enough detail, and that it implied that some of these rights were not already held by victims of crimes. Like there already is a statutory right to restitution, for example. Most of the time, the reason you can't get restitution is not because you don't have a right to it, it's because the defendant is judgment-proof. There's defending the assets, and certainly no earnings while they're in prison. So that was what Judge Wingate said, and we'll get a lot more clarification from the state Supreme Court on what those requirements mean in practice when they decide, did this ballot initiative, and most importantly, the language that appeared on the ballot, did it meet those requirements? Because right now there's not that much law in Kentucky on that, and we'll know a lot more after, assuming the state Supreme Court takes it, which I'm sure they will, what they say about it.
I'm still a little confused because I've done a little research into the proposition itself, and I know that on its face like Ellie said, it would seem like something that everyone would want. They would want like both sides to have a fair balance. What exactly are the constitutional issues that people are concerned about?
Well, on the merits, the issue. I mean, there's a whole issue about whether it was fairly worded or whether it was done in a way that was misleading to voters. That's one issue. Let's assume that the ballot initiative language either was proper or could be made to be proper so they could try again. Either way, the constitutional claim against it is that at least some aspects of it would interfere with the due process rights of defendants. For example, if in a situation a victim said, I want to be present at the hearing, at every hearing, and I get to be heard at all these hearings, would that at least potentially interfere with the right of the defendant to a speedy trial? Mm-hmm. Because it could cause delays as the prosecution, if the prosecution fails to notify the victim and then something has to be delayed, what does that mean for a speedy trial right? So that's just one example of the way these rights can come into conflict and how do courts resolve them. I personally think that a lot of those concerns are at least manageable, but they would require in the law, they would take quite a while to work out on a right by right basis, and ultimately the court, in balancing those rights, the courts would say, here's how we put that into practice and balance the rights of a criminal defendant versus those of the victim under this constitutional amendment. But during the time it takes to work those issues out, there'd be a lot of controversies. Eventually you'd end up with a balance between them, and the rights of the criminal defendant would have to be preserved. Okay. But we'll see. It may or may not go into effect. If it does, I'll say just two more things. One is, if it doesn't go into effect, you can certainly expect the General Assembly to try again and just use better, more accurate, and more helpful ballot language. And then second, don't ignore politics. Politics informs law on two levels in this case. One is, the Kentucky Supreme Court is going to be under a lot of pressure when it decides this case to uphold Marzy's law, because it was approved by almost 65% of the voters. We would hope that judges can ignore politics, put that aside when they issue rulings and hear cases, but that can be tough, and often politics inform the way courts perform their job, especially when those judges, including Supreme Court justices in a state like Kentucky, are elected. So politics may make a difference, even though we would hope at some level it doesn't. And then second, the politics of Marsy's law itself from the legislative perspective, right? This, for some of you who may know this, some of you may not, this was it's not just happening in Kentucky, so I don't mean to suggest that it was entirely the creation of Senator Westerfield, who's the chair of the Judiciary Committee in the Senate, the state Senate. But it was he who drove it. He was the major sponsor. He pushed it, got it through, and he has ambitions. He ran for Attorney General last time, lost to Andy Beshear, and he's running again. He's already announced he's running again. So and I guarantee you, he will use Marsy's law as a big part of his platform. He'll take credit for it and claim it as him standing up for the victims of crime. So politics makes a difference in law, and if you forget that or ignore it or wish it away, it's not going to go away, and it can affect the way you have to litigate cases sometimes and how the law develops. So just that. All right, let's talk about Lauria. First of all, I think there needs to be a TV show about Stella Weeks, right? That's a perfect name for this heroin police detective. And so one of you, hopefully, will someday become a big shot TV producer or a legal advisor to a network, and you will carry this into reality, because it would be one of my dreams come true. Because I love her. So what happened in January 1965, Mr. Johnson?
So the police, I think before all of this, were looking at 3 prostitutes, or investigating 3 prostitutes.
3 prostitutes?
I thought Terry was one of the 3 prostitutes under investigation, but Stella Weeks.
And how did the investigation of prostitutes end up translating into this case?
Because they referred, the Stella Weeks went undercover and was referred by one of the prostitutes, Terry, to the call answering service. An
answering service? Do you even know what an answering service was?
I think that was around when dinosaurs went extinct. I don't remember. I'm just kidding. No, I feel like it's equivalent to like Facebook Messenger today. But it's like a medium, and they just pass along messages, kind of. So. Somebody has a better definition, though.
I could give it a shot.
Does anyone want to answer that question in a way that doesn't break my heart and make me feel like I might as well be put out to pasture? Just can.
Is it where you can hire the services of like an operator to take your phone calls and
not
take
an
messages?
Operator exactly, because operator also used to exist. Right. Like the phone company had an operator who could help you make a call, put you through a number, and this is all you're thinking like, what the hell?
No, I know.
Is it the party line thing?
Yeah.
It's not a party line. There's a service. It's a private service. And why would you need this? Because today, every call comes right to you. You don't need anybody to get your calls for you.
Right. Back in the day, if you had a high volume of calls, you wouldn't want all of those clogging up your answering machine. You'd want them organized.
No, this is pre-answering machine. A lot of you are like, answering machine, what's that? Right? This is pre-answering machine. Answering machine was the first nail in the coffin of answering services. Because then it would be automated. You can just have this little machine with a cassette tape on your desk, and that would take your calls when you weren't there. But before that, you needed a service for this. And this is how, and a great example of how automation and technology is killing the American worker. Because how many jobs have been eliminated, first by answering machines and then by cell phones? This whole business has been just out of existence, right? Like an asteroid hit 80 million. Right?
Are you still wanting a definition of the call service?
No,
Oh,
I
that's
think
what
right? So you would hire these people, and they would, for a fee, sometimes per call, sometimes just a flat fee, and they would get your messages, take them for you, and then you would call into your service, and you'd say, oh, how many messages do I have? Oh, you have 15 messages, Mr. Loria, and then you pick them up, and it would make your business much more efficient. You wouldn't miss calls, etc. Okay, so that's an answering service. Okay, so why did Stella Weeks sign up as this undercover police officer with Loria?
She believed that he was because this service took calls from prostitutes and it kind of helped their business.
So the prostitutes were using the service,
yes, sir.
and she's gonna
Busted.
pose as a prostitute using his service.
Yes, sir. Yeah.
And the idea was prostitutes were using the service. They would get calls from their customers, and their customers are called
tricks.
Tricks. That is not the word of the day, however. Although it would have been a good one. Because if you're a prostitute, you don't want to miss your calls because that's your living.
Yeah.
You make a living by making sure you are responding to your calls. So an answering machine is great for you. So she wants to create the impression with Loria that she is
A prostitute.
not a police officer. No, I'm really a prostitute. So how does she do that?
She does that by she calls them and it says she made it open, I think, or kind of she gave concern with the secret. Okay, she hinted broadly that she was a prostitute, concerned with the secrecy of her activities. Then she found out that it was a discreet service from police, so that they could be safe. And then
Lori's like, don't worry, we are very discreet. The police will never know. So this goes on, and how does she then follow up later to also reinforce the idea that to leave no doubt, to be able to persuade a fact finder that Loria knew exactly who he at least thought he was dealing with.
she referred to her clients as tricks,
John.
and that
As
she
tricks.
missed
She said,
$100.
look, I've missed calls.
Yeah.
What's going on here? And what did Loria say?
Loria said that didn't he say that somebody could find nothing wrong with, and said she would alert the switchboard operator about slip-ups on calls.
And by the way, these friends probably lied to you about calling, because my service is stellar, right? We are a grade A answering service. But then, how did he respond to her hints? This is my favorite part of the whole case. To her hints that, hey, look, I need my customers if I'm going to make a living, right? I can't miss calls. How did he respond to that?
He said, his business was taking messages. Is that, or which
Yeah,
part?
but what else did he say?
He invited her to come over to his house.
Oh.
To get better
To
acquainted.
get better.
And anybody want to have any guess what that means, right?
Oh, God.
So he knows what's going on, right?
Yeah.
So she complains about missed calls again and refers to the callers as a $50 and $100 trip. And this is, 1965. She's, posing as a pretty high-price prostitute at those numbers. So what happens now?
So then, on April 1st, the Loria and the 3 prostitutes were arrested. And then, so they went to trial. Loria was indicted.
Wait. Before you get to trial.
Oh, no, they
What
set aside.
does he say to the police?
He got mad. He complained that because Hollywood, they have a lot more prostitutes in their call service.
Yeah, I'm a small potatoes.
Yeah.
Why are you picking on me? I only have 9 or 10, and I just tolerate them. I keep separate records so I can cooperate with the police.
But he just admitted it.
And he says, what does he say to the grand jury?
However, his service didn't arbitrate.
About one of the 3.
He had always cooperated, but wait.
He knew Terry was a prostitute.
Oh yeah, he knew she was a prostitute.
Because he had personally used her services.
Dang, you got it. And he knew she was paying for 500 calls a month. So
She's apparently a prostitute with a large client base.
high demand.
Right? 500 calls a month. Okay. So he's indicted for conspiracy to commit prostitution. The trial court, what does the trial court do?
Sets it aside, so
Dismisses
it.
the indictment. Says, no, there's not as a matter of law, there's no need for a trial because the legal theory, the legal basis for this indictment is invalid. So dismiss the indictment. Since there's been no trial and he hasn't been acquitted, the prosecution can appeal that legal ruling. 95, 99, a huge, overwhelming percentage of the time, if the defendant wins, the prosecution can't appeal, right? Because they've won at trial, that's the end of the story, even if there might have been an error in the trial. But this is the exception. If the thing is dismissed, if the indictment is dismissed before there ever is a trial and a jury impaneled, then there's no problem with double jeopardy, there's no problem with the prosecution appealing. And they do appeal here. They say, wait, and our legal theory is perfectly good. The trial judge was wrong. We should have gotten to try and attempt to convict Lauria. Okay? So what is that theory? What is that theory of the conspiracy and Lauria's role in it?
That he knew that he had.
What was that word again?
Knew.
Knew. Okay? I want to really emphasize that. Lauria, this is the state. Lauria knew. Go ahead.
And I was going to say that he had a tacit mutual understanding between the co-conspirators to accomplish an unlawful act.
If you look on 873, the prosecution argues Lauria, well aware that, i.e. knowing that his co-defendants were prostitutes who received business calls from customers through his answering service,
continue to furnish them.
he knew his business was being used for the illegal purpose and continued with that knowledge to furnish his service. Thus, he was in a conspiracy, a tacit agreement, but you don't remember, it doesn't have to be explicit for conspiracy. The agreement doesn't have to be explicit. There's a tacit understanding or agreement to do this. Work jointly. They benefit because they have the answering service to further their prostitution, to further the illegal purpose. And he benefits because he has more business for his answering service. Not as much as this other one, he claims, but so what?
So, sorry, I might be jumping the gun here, but is this a question of whether the mens rea matches up with the crime? Because
it is, but we'll get there. This is right now we're just talking about the state's theory. State's theory is all it needs to show, and it's sufficient, and they say, well, we can show this if this is the right test. You can be convicted. If you're somebody upon whom we're basing our case is the idea that you furnished a service or a good product, all we need to show is that you knew that it was being used for illegal purposes. Okay? As the government, so the question is, under what circumstances does a supplier, here a supplier of answering service, become part of the conspiracy to further an illegal enterprise by furnishing goods and services which he knows, not suspects, not believes, not thinks, well, maybe, but he knows are to be used by the buyer, here are prostitutes, for the criminal purposes. All right, who wants to be my prosecutor? I need a prosecutor, Ramaswamy, and a defense lawyer. You don't even know what I'm going to do with these, but Mr. Cannon. Okay. The court begins by discussing two prominent precedents from the U.S. Supreme Court. Which one do you like, Ms. Ramaswamy?
Oh, the direct sales one. Direct sales case.
Why?
Because it was a, I think, physician who was supplying the narcotics, which another, I think physician was then like distributing, and they found him guilty of conspiracy.
So tell me how you would argue, I'm the appellate judge. Tell me why direct sales supports your theory that this decision by the district court, the trial court, should be reversed, and that Gloria can be at least potentially convicted, why the indictment should be reinstated.
Well, the facts are, pretty much aligned. That Gloria knew about the illegal services that were being
Just like
in direct sales,
The-
just like the physician who knew that he was supplying narcotics to another physician.
so knowledge of supplying a good that it is being used illegally is enough to make the furnisher of the good culpable for conspiracy. Open and shut case. We got a direct precedent right on point. Direct sales. Is that true, Mr. Defense Lawyer?
No.
Why not?
Well, there's this great case, State versus Falcone, and it's quite similar to the direct sales case. But
Don't say that. You want to say it's similar to this case.
Sorry, it's quite similar to this case in that the wholesaler was selling large quantities of yeast and sugar and other innocuous.
Sounds like a baker.
Right, yeah, exactly.
I use sugar and yeast all the
Right,
time.
yeah, ladies and gentlemen of the jury, how often do you buy yeast and sugar? Probably quite often. How often do you lend it to your neighbor? Maybe equally as often. But
I don't like my neighbors.
yeah. So the Supreme Court ruled that the wholesaler had couldn't be indicted for conspiracy because they didn't have the duty to exercise discretion as to what those goods were going to be.
Would they
used
to be
for.
used for making a loaf of bread?
They were going to be. They ended up being used for moonshine.
Moonshining, you say?
Oh, good.
Ms. Ramaswamy, you chose the wrong side. You should have been the defense. Moonshining. That's my kind of word today. So, knowledge in the moonshining case was held not to be enough,
Right.
even though you're furnishing service, even though he knew it was being used for moonshining in an illegal way. So their knowledge was not enough, whereas in direct sales, knowledge was enough. So what are we to do? You've been doing this in lawyering skills. You've been building up this sort of what do we do with point precedents that point in opposite directions? What is the lawyer's job when you have these two precedents? Mr. Cannon, what's your job?
I want to distinguish direct sales.
And how are you going to do that?
I'm going to say that in that case, it's substantially different in that they were dealing in narcotics that.
Okay, well that's a factual difference, but why is it a difference? Why is it a distinction with a difference? What is the principle that makes that different, other than just that yes, that case didn't involve prostitutes?
Right. Well, but maybe I read it wrong, but I thought that it was just that, like they had a duty to.
Why? What is it about what was involved in direct sales that makes it different?
The nature of the product.
What in the nature of the product?
That you're selling a large quantity of drugs to a doctor.
This was a large quantity of prostitutes.
No, it wasn't.
That's not. It's one of those large volume calls. That's not the. That's.
Okay.
It's not just the volume. What is it, Ms. Richter?
The narcotics are either illegal or controlled in some way.
Well, the prostitution's illegal. The dangerousness of the product. The court says the difference between direct sales and Falcone is that these are innocuous everyday products. Right? These are innocuous everyday products. And the court says on page 873, the distributors of such dangerous products as drugs are held to a higher standard to, quote, exercise greater discrimination in the conduct of their business than the purveyors of innocuous substances like sugar. okay? There's a difference in the nature of what's involved here. The seriousness of the crime, the harm that the good or the service can do. Is that a satisfying line to draw? What if the product were fertilizer? Is that innocuous or is that dangerous?
Large quantities of fertilizer can be dangerous because they can't explode.
So the line doesn't really get us anywhere if we're just trying to make it based on dangerousness. So this is danger, Will Robinson. This is generally harmless. And you're trying to say that it's not just a fine, clear line between that, because some products might be dangerous depending on the circumstances. And so we don't get as far as we want to get, at least, with this test. What about gunpowder?
Same thing, large quantities, big explosion.
Large quantity, especially in combination with fertilizer.
Yeah.
So it's not just the quantities, it's what do you buy it with, perhaps.
I think it's also important, like, what's necessary in order to accomplish the crime. Like, in Falcone, like, the suppliers could have gone to almost anywhere else to get sugar beets, but in direct sales, and similarly, I guess, like, from a standpoint.
Can you do that again?
Like, how necessary it is to get it from one particular supplier. Like in Falcone, you can find sugar.
But that's looking at it, at least arguably, from the point of view not of the supplier, but the consumer. Right? Because we're trying to say, are we holding the supplier culpable for a conspiracy? What is the underlying reason why we would say danger, it's fairer or a better outcome or a justified line to hold somebody culpable with a dangerous product versus sugar when you're selling it? You're selling these drugs as a wholesaler. Remember, we're not talking about cocaine here. We're talking about what can be at least an illegal drug, but you're selling it illegally. What's the reason, Mr. Webb?
I think you kind of accept that risk. Like, that's part of, like, the risk of doing business almost.
Why?
There's an expectation to know that these things are dangerous when you agree to sell them as part of your business.
Good. I'm really glad you said that. If I understand Mr. Webb correctly, he's saying, well, if you're selling something like drugs or gunpowder, it puts you on notice that it might be used in a way that's dangerous, so we're going to hold you to a higher standard. Whereas sugar, who's on notice that that might be used illegally, right? How many bags of sugar does your average Kroger sell a day? Right? You know, and most of it's used for common household reasons. You're not on notice of that. If the fact that this puts you on notice because of its dangerous nature, and this doesn't put you on notice because of its innocuous nature, what's the problem with that? What's the problem with that as an explanation for this distinction? If the distinction is with drugs or gunpowder or fertilizer, you should have known. You were on notice. Why wouldn't that be, or could you argue at least, that shouldn't be a defense for somebody like Gloria in the innocuous category?
Isn't it a bit subjective to an extent? Like, we consider drugs.
Let's say we have a crystal ball, and I think it's a great point, but I want to put it aside by saying, let's say we have sort of this ability to decide with absolute certainty who and who should not have known. Because I don't want that to trip us up. Did
you already know that he knew?
Boom. Excellent. Right? He knew. So the question is not, did this put the moonshiner on notice that's selling sugar? Who cares if he should have known? He did know. In cases where you have actual knowledge, relying on this doesn't make any real sense. Right? Because if the prosecution must show that they actually knew, that it was being used for illegal purposes, then these two equally were on notice by their actual knowledge of the illegal use. So I don't think that gets us where we want to go. So what line do we ultimately get to?
Are the difference between a felony and a misdemeanor?
Well, yes. That if it's a really serious felony, then we can might be able to use the knowledge standard. But what line do we draw? Intent. Our rule that we're going to get to is that it's not enough that you knew your business was being used, but you must intend to further the illegal use of the product, rather than just having knowledge. And so our mens rea for conspiracy, at least under these circumstances, is that you intend to further the conspiracy and its underlying crime. Okay? Intent to further, not just knowledge. Not just knowledge. And we do that because we don't think that when it comes to minor offenses, that it's worth society's time imposing this duty to make everyone basically a deputized police officer, a deputy sheriff charged with enforcing the law every time you know it's being violated, right? But with serious crimes, we might make the rule different because society benefits more if we impose that duty on you. But the general rule, unless the law sets forth otherwise in the jurisdiction, is intent must be shown. Intent to further the conspiracy. So how can you show intent?
You can infer it.
You can infer it. It can be direct evidence, right? If Loria had said something like to Ms. Weeks, or if he'd said it to one of his prostitutes and it was caught on a wire, if he'd said, my only reason for keeping up this stupid business, which takes all my time, all my energy, is because I think it's critical to the prostitution trade in this city, and I want that to be my mission in life. Right? He intends to further. Okay, so it can be direct evidence or circumstantial evidence from which the jury can further infer the intent to further the criminal enterprise. What's the indirect evidence? What kinds of things does the court suggest, Ms. Mwanga, might be that indirect evidence?
They say when the purveyor acquires a stake in the...
How would that translate into Loria, if
So,
you had this as a fact?
I think he was getting maybe a cut from the
Perfect.
proceedings.
Excellent, right? And that would almost make him a pimp. But that's not true here, or it doesn't seem to be, but that's a factor. That's one thing you want to have on your checklist of things that a prosecutor could use to meet the intent requirement. Ms. Richter?
Can't you also, it says something about the aggravated nature of the crime, so if the crime is more violent or something?
Well, that's on if it's a really serious crime.
Okay.
Then you may be able to use knowledge alone. But we're talking now about what's enough, or how can you, a prosecutor, prove intent when direct evidence isn't available. Ms. Call, do you have another factor?
When no legitimate use for the ninja services exist.
Yeah, the jury can infer, look, if there's no reason other than crime or furthering a criminal conspiracy for this service, if you advertise that your business is providing getaway cars for bank robbers, well, there's no other reason for getaway cars for bank robbers than to further a bank robbery conspiracy, right? Or if the volume of the business is grossly disproportionate to any legitimate demand, that becomes that reason for the business, right? It's not a legitimate business just being used, but the business itself, the purpose of it, is that of the criminals. They are a shared enterprise.
Sorry, I don't mean to cut you off, but if I'm the prosecutor, and it does seem like at one point they talk about paying per call, what about the fact that he was benefiting from these call girls receiving high volumes of calls?
But that doesn't. There's nothing in here that tells us that he had a high volume. That her volume of calls was a huge percentage of his business.
But it just
Because
says you have to have a stake.
yes, she had 500
right?
calls, but he may have been taking 50,000 a month.
Right, but it doesn't specify how big the stake has to be, does it? Just a stake in general?
Well, but in theory, that's right.
Okay.
But here,
It doesn't matter.
here there's apparently no evidence that, or not sufficient evidence that the
That was-
prosecution even could prevail.
Okay.
Okay? Questions? So there's, first, if it's a relatively minor offense, I think we can put prostitution on that side of the scale. In Nevada, it's even legal. Then you have to show intent to further the conspiracy and the crime. If it's a really serious crime, then knowledge might be enough.
Is the cutoff between like minor and serious misdemeanor felony?
No, I think there could even be some relatively minor felonies. It's not that clean. I wish it were, but no. Okay? Let's talk about Diaz. This is a whole complicated fact pattern. So let's work through it. Clemens, what happened?
Okay, so this is a DEA drug sting operation. So you have a number of people involved. You have, starting out, Perez, who contacted Rodriguez to find some cocaine suppliers. He said he knew someone who could help Perez out and arranged a meeting with Rodriguez, Perez, or himself, Perez, and Mr. Diaz.
Okay.
And Mr. Diaz agreed to supply the drugs to Perez.
With Rodriguez having been the middleman. Okay?
So on 2 occasions, on August 21st and September 3rd, Perez sold 2 ounces of cocaine to a DEA agent, Collins.
So Perez is a bad retailer.
Yeah.
Because he cannot spot the DEA agents very successfully. And so now Perez becomes helpful to the government, or at least does at trial. What does he say about the drugs he got, or the drugs that he sold to the DEA agent?
He said, well,
Where did he
I
get
mean,
them?
he says where he got them
Which
from.
was?
So he got them from Mr. Diaz.
From Diaz,
who
right?
was not present at either of those 2 sales, but he brought the money back to Diaz after the second sale, so he implicates him in it.
And then Rodriguez and Perez said that they dropped the money from these sales with Diaz after the second sale. So then what happened on September 9th?
Perez and Rodriguez went to meet Diaz to sell an entire kilogram of cocaine to Agent Collins. And at first Diaz wasn't there because he thought it was happening closer to his home, so they called Diaz to agree to join them. And then 5 minutes after Diaz arrives, Pierlo arrived?
Perallo, I think.
Perallo, okay. Who brought the kilogram of cocaine. So they waited a full hour for Agent Collins.
This is like an episode of Miami Vice, by the way. Anybody remember, have anybody seen reruns of the 80s Miami Vice, Don Johnson? This is like late 80s, all the Miami drug trade, undercover agents. It's perfect. Okay?
So Perallo became impatient, so he left, but then Agent Collins...
And Perallo is the supplier.
Yeah.
The supplier. He brings all this cocaine,
He had the
kilo.
drugs.
And he
So-
says, I'm done with this. He says, I want to be paged when Collins, who it turns out is a DEA agent, arrives, okay?
So they page her, and of course he comes back. Perez joins Agent Collins in her car. He counted the money from her. Then he met with Diaz to confirm that Perallo was on his way, which he was. He returned back to Collins' car. And then when Perallo got there, their cars were all lined up. So Perallo was first, Diaz and Rodriguez were in the second car, and Agent Collins with Perez was sitting in the third car.
Okay, so Perallo got there.
So when he arrived, Diaz and Rodriguez, they went to Diaz's car. Diaz opened the hood. He claimed it was because of car trouble, but the government says that's standard to prevent buyers from seeing the supplier, which was Perallo. Perez left Collins' car with the money. He went to Perallo's car to give him the money. Perallo told him that he had a gun in case somebody...
Hold stop there. You said Perallo had a gun. Anybody else have a gun?
No.
No. Perallo has the gun. That's really going to be important. Perallo has a gun. Okay? And he told him he had a gun, and I am going to use it if anyone tries to steal the drugs without me getting paid. Right? Okay?
So then Perez, he takes the drugs back to Collins while Diaz and Rodriguez just stay in the second car and watch. And then when he gives Agent Collins the drugs, Collins signals for the arrest, and then they are arrested.
And what is Diaz convicted of that's relevant?
Of carrying a firearm in relation to the commission of drug trafficking crimes.
Diaz convicted of using a gun in commission of drug trafficking. And why is that important?
So he didn't actually have a gun on him.
No, I mean, but why is that conviction significant legally?
Because it was based on the conspiracy.
And that's the ultimate issue.
He got more time in prison.
He got more time in prison. And that was 5 more years,
Yeah.
right? 5 extra years. So that's important to Diaz. But we just said Diaz, unlike Janie, hasn't got a gun. I'm waiting to say that all day. But Perallo did. So on what basis can the government say Diaz is culpable when Perallo's the one who had the gun?
They say that they can do that because of Pinkerton v. U.S.
So it's Perallo's carrying of a gun, the government says, can be imputed to Diaz. Why? Because of their joint membership in the conspiracy. So the actions of one conspirator it's not about holding Diaz liable for the conspiracy, but for the substantive crime of using a gun. And you said the government relies on
Pinkerton.
Pinkerton. Pinkerton is a huge case when it comes to conspiracy law. What is the Pinkerton doctrine?
It says when the substantive offense is committed by one of the conspirators in furtherance of the conspiracy, then that's when you can make a party responsible for what the others do.
An act committed in furtherance of the conspiracy by one conspirator is chargeable to all conspirators. That's Pinkerton, with one footnote. I'll add in a minute. All it has to be is that the act was in furtherance of the conspiracy. Even if Diaz didn't know that Perallo was bringing a gun or had a gun, what does have to be true? There's the footnote. He doesn't have to know, but
well, he doesn't have to know, but there's an exception to it.
it's not really an exception exactly.
Well, it's just like unless the crime could not be reasonably foreseen.
Good. Excellent. Right? An act, as long as the crime we're talking about, the act, was foreseeable. So Diaz didn't have to know, the prosecution doesn't have to prove Diaz knew Perallo had a gun. All it has to prove is that it was foreseeable that he might. So if it was foreseeable and in furtherance of the conspiracy, all the co-conspirators are culpable for the substantive crime, not just for conspiracy. So the moral of the story is be awfully careful who you conspire with, because if they start doing other wrong things, you're going to be liable for their other wrong things as long as it was foreseeable they might, and as long as the other wrong things furthered the conspiracy. Okay? That's Pinkerton. Everyone understand the Pinkerton rule? Maybe you have any issues with that, other than you may disagree with it, but okay? What happens to Diaz under that rule?
he does end up getting convicted because they say that conspiring to sell a whole kilogram of cocaine on the street worth $39,000 is a situation where it's pretty reasonable that there would be some kind of weapon there.
Good. Now, what does the model penal code have to say about Pinkerton? Richter?
It rejects it, and it says that if the defendant is not the direct perpetrator of the crime, then he must be proved guilty by the rules of accomplice liability.
Which is to say complicity.
Yeah, and the prosecution cannot benefit from what they call the Pinkerton upgrade, I guess, to conspiracy. The way it worded
What's
it
the
was.
difference between that rule, the complicity rule for co-conspirator liability, and the Pinkerton rule? Where does the difference come in? If this is the Pinkerton rule, and I asked you to clearly define the difference between Pinkerton and MPC, what is different? This is much more favorable to the prosecution. In what way is the MPC rule more favorable to the defense?
So if they have to prove complicity instead of conspiracy.
And what would that involve? What more does that mean?
I'm trying to remember.
You didn't do it that long ago. Mr. Razor?
Oh, it just says it's by his own conduct. So
I beg your pardon?
It says by his own conduct.
Does, not quite.
Do they not have to do an agreement, I think?
They have they have to have a conspiracy at all, right? So you have to be a conspirator, you have to have an agreement. What more, if I'm Diaz, if the prosecution has to proceed under MPC, and by the way, KRS, under 502.020, what more does the prosecution have to show to render Diaz liable for Perallo's use of a gun? It's not enough, I'm telling you, that it was foreseeable, and it's not enough that it was in furtherance of the conspiracy. What more next has to be shown?
No, we haven't done.
Not just, no, almost.
He had to share that intent.
You have to share, remember, the accomplice liability, you have to share the intent of the principal. So the prosecution under model penal code has to show not only that the act was in furtherance of the conspiracy, but that Diaz here intended to further the criminal act, that is, the possession of the gun. That's a big additional step in favor of the defense, and that the prosecution has to prove that you shared the intent. Under Pinkerton, doesn't matter. You were in the conspiracy. Now let me give you a big, long hypo that we'll work through all together to illustrate how much of a difference this can make. Okay? So get these all down, get these people down. A, let's call this person A, is the organizer and ringleader of a conspiracy to rob banks. Okay? We got A down, organizer and ringleader of a bank robbery conspiracy. A hires B and C to rob banks 1 and 2. Okay? B is going to rob bank 1, P and C, if you like, and C is going to rob first, third. Okay, so B is going to rob bank 1, C is going to rob bank 2. B and C do not meet face to face, but they both know that they are members of a larger conspiracy, and each knows of the other's assignment. Okay? Finally, at A's instigation, D, knowing of the conspiracy, steals a car for use in the robberies. Okay? D steals a car for use in the robberies. B and C each perform their robberies, but only B uses the car that D stole. Everyone got the facts? Want me to go over any of them again? B and C perform their robberies, and B, but not C, uses the car that D stole. Okay? So I'm going to go through each party, and they're going to be A, B, C, D. Actually, one space between them. A, B, C, and D. And we're going to say on Pinkerton and under NPC. Would each of these people be liable or culpable? Okay? Under Pinkerton, would A be culpable? And if so, for what? Mr. Blank, I saw you nod.
Yes.
Your answer is?
Under Pinkerton, yes. It would
For?
be culpable for bank robbery.
With how many counts?
2.
Because there's 2 banks that were robbed. And remember, we're assuming these folks are all liable for conspiracy. Right? Conspiracy is the bedrock, the foundation given. Now we're asking for what substantive crimes can they be charged. So 2 counts of bank robbery. Anything else? And car theft, because they were in furtherance of the conspiracy and they were foreseeable. Right? So yes, the bank robberies and the car theft furthered conspiracy and foreseeable. That's all you need. Mr. Blank, what about under the Model Penal Code?
Not be for the car, but yes for the banks.
Why not for the car?
Because it wasn't furthered for.
What else do we need?
Shared intent.
I'm sorry? What else do we need? Does A share the intent to steal the car? He sure does. So this illustrates where it doesn't make a difference, because the facts can prove either one. That A shared the intent to commit both bank robbery and auto theft. Remember, I said A instigated A's instigation, D stole the car to aid in the bank robberies. So A furthered and had the intent to further both the bank robberies, and he purposely encouraged the commission of all those crimes. Okay? So now B, and for that matter C, we can do B and C together in a way. Under Pinkerton, can B be culpable for C's robbery, and can C be culpable for B's? The answer is the same as to both. Under Pinkerton.
Yes.
Why?
Because it doesn't matter if they knew each other were doing it on a
Louder.
It doesn't matter that they knew each other were doing it. It just matters that they were trying to further the crime.
Both robberies furthered the conspiracy and were foreseeable. Okay? What about B and C for D's theft of the auto under Pinkerton?
No.
Why?
Because B did not show the intent to share.
Under Pinkerton.
Oh, under Pinkerton?
Under Pinkerton, can B and C be liable for D's theft of the car?
Yes.
Yes, for sure?
I don't think they know that the car was
Do they have to know?
No.
What has to be true?
It has to be foreseeable.
Has to be foreseeable.
But if you know,
Prosecution's going to argue.
he doesn't know.
Doesn't matter if you do.
Yeah.
You just said that.
Argue that it's foreseeable that
The
he
prosecution's
was
going to say, of course it was foreseeable. Defense is going to say, that wasn't foreseeable. Maybe they'd have their own car. Who knows it would be foreseeable to steal a car? So the answer is yes, if.
Okay.
So B and C, as for D, that is the theft of the car, yes, if prosecution can show it's foreseeable. It certainly was in furtherance of the conspiracy. The fact question would be, was that foreseeable? And I can see a jury going either way on that. Right? If you're willing to rob banks, it's foreseeable. You're willing to steal a car to provide a getaway car. I can see a jury saying, no, that's a step too far. That wouldn't be something you would expect reasonably. Could go either way. But that's the question you have to ask. Was it foreseeable? Because the furtherance question, we check that box easily. Okay? Now, what about B and C for each other's robbery under complicity theory, or that is the MPC?
Show the intent of the principal.
I would argue that they were only be liable for their bank robbery.
Because?
They didn't show the intent to rob the other bank.
Good. Now, if we had other facts from which we could prove that they actually encouraged one another in some way, or shared the intent, and therefore had the purpose, had a stake in the other's venture, right? B would profit from C's bank robbery, then yes. Then we might be able to show the required intent. I'll keep on drilling that home. Under this rule, what you need is intent to further the criminal act, not intent to further the conspiracy. You're already liable for conspiracy. Intent to further, in B's case, C's bank robbery, and in C's case, B's bank robbery. So no, unless evidence is enough to show B and or C had the intent to further the other's robbery. Okay? Everyone see that? The difference that makes whether you use Pinkerton here or whether you use the Model Penal Code / KRS? Huge difference. Okay? And that's also true, by the way,
For the car.
when it comes to B and C for D's theft of the car. They didn't have the intent to further that under the MPC. So that they get a yes if, under here, you get a no. Again, unless you have evidence you wouldn't expect, right? There was neither agreement to rob to rob, nor the robbery itself aided the theft. So nothing they did in the evidence we have and the facts I gave you suggest that they intended to encourage or did encourage the theft of the auto. Okay. Okay, and that leaves us with D. What about D for C? For C's robbery under Pinkerton, D for both robberies.
I think yes.
Why?
Because it furthered the conspiracy, and it was foreseeable because it can be proved that it was foreseeable because he was told by A, right?
It was in furtherance, and it was sure foreseeable that if you steal a car that you're told is to be used in bank robberies, that is going to further the bank robberies. Right? So it was in furtherance, and it was foreseeable for both robberies. What about under the Model Penal Code? Is D liable for both robberies?
I would say yes, because the intent was for the robbery, but he didn't rob the bank, so
You're an optimistic
tricky.
prosecutor, Mr. Johnson. Is Richter?
I think it can only be held accountable for taking the car and for helping with what
Well,
C.
taking the car, we got him on that because he did it himself.
And then the robbery that C committed, where the car was actually used.
The car was used in B's.
Or B, yeah.
Right. So here it would be yes, but only for B. Okay? Now, if we had facts that showed that C was encouraged merely by knowing there was a car available, then you could maybe build that case. But I didn't give you any fact like that, so don't assume it. Okay? Let's look at 502.020, because I want you to see how a statute is written that creates this different rule than the Pinkerton rule, right? If you look at 502.020, it says, a person is guilty of an offense committed by another person, that is, all these people with crimes committed by others, when with the intention of promoting or facilitating the commission of that offense. There you get your intent element, right? We say this rule requires intent, there it is. So you have to have the intention of promoting or facilitating the commission of the offense. What do? Look at A. You solicit, you command, or you engage in a conspiracy with such other person. So that's our link to conspiracy. Right? So if you conspire with a person, you are liable for the offense they commit if you act with the intention of promoting or facilitating the commission of that offense. Everyone see how those words, how that construction leads to, if you conspire with a person, you're guilty for the substantive crimes they commit if you intended. Not just if they were foreseeable, not just if they furthered the conspiracy, but if you intended to promote or facilitate the commission of the offense.
If we're on our exam and we have an essay question that is like this, would we want to make a statement that says, like, if C was encouraged by knowing that the car was available, then you could argue with model penal code were totally applicable, or should we just leave that
The
out?
key is clarity. If you, if I ask you, can so-and-so be charged with something, then you might want to say, you could say, and it would be fine to say, let's say you're talking to your client or you're the prosecutor making a recommendation to your boss, the Commonwealth's attorney or the U.S. attorney. I recommend that we file these charges. I am not recommending that we file charge X because on the facts known to me, we don't have this intent element. If, however, additional facts arise by which we could prove intent, then such a charge might be possible. So don't ever just tell me, oh, it depends. Tell me what more you would need. But it will be perfectly fine if you just rely on the facts that I give you and say this, and maybe you want to explain why you wouldn't charge somebody based on the facts you were given. It'll certainly be enough to say, we should not charge B with C's robbery because that's why I gave you it in Kentucky, because under 502.020, there is no evidence that B intended to further the commission of C's bank robbery. Then you're telling me what you know the rule, and you're telling me why you chose not to bring that charge.
Could you repeat why B and C aren't liable for D's auto theft under the model penal code?
What evidence do you have that they intended to further the commission of the auto theft?
You don't, unless they were relying on it in some way. You don't have that fact.
But even if they were relying on it, there's got to be something they did or that they acted with that proves their intent to further. A, you've got that.
Intent to further the theft.
Intent to further the theft of the car. Because that's the intent we care about. The intent we care about is, did you intend to further the crime you are charged with by the fact that you were in the conspiracy? Here, in that the particular one you're asking about is the theft of the car. That's the crime we would be charging with. Did B and C intend to further that crime? It's hard to make that case without more facts. You sure?
Yeah.
All right. Okay? Everyone got this? I'm confident that this will be something you will all want to ask questions about at the, just if history is any guide, at our review session, which, by the way, there will be a review session. We'll schedule that probably next week. One other thing I want to mention, also in my head, about our schedule is somebody's mentioned to me the other day that since we have that day, the 20th, that is currently free, it would be a good idea to have that time available and maybe do some sort of something in that session. And what I thought I would do is make it available on a voluntary basis. No one has to come, and do some talk to you a little bit about how what my exam expectations are, procedural stuff, not substantive review, but how I approach the exam, how you can approach the exam, those sorts of questions. And so I think we'll probably do that on the 20th, but it won't be mandatory, assuming we get through the material. But that's what I'm thinking about. Okay, let's talk about Caldwell, where we explore the wonderful, helpful, easy to understand world of bilateral, unilateral, and chain spoke conspiracies. The indictment here alleged that the defendants, Caldwell, Anderson, and Herrera, were involved in a conspiracy. According to the government, Herrera was a supplier for both Anderson, a street dealer, and Caldwell. So we know, according to the indictment, that Herrera was a supplier for Anderson and Caldwell. Okay? Herrera was a supplier for Anderson and Caldwell. The jury concluded that the three men, I'm laced here. The three men entered into a single conspiracy. Why is it important that whether they entered into a single conspiracy?
The total amount of drugs that they sold, they can be held to a higher offense.
Because if you look at all of what Herrera supplied to Anderson and Caldwell, it goes over 100 kilograms. Right? 100 kilos. And if it's over 100 kilos, it's a more serious offense. But if you look just at what Herrera supplied to Anderson, it's under 100. So the last thing Anderson wants is to have this be seen as a single conspiracy, being lumped in with all of them, right? Everyone see why that's really significant? If you're representing Anderson, you want to say, no, this was separate conspiracies. I had nothing to do with Caldwell. As we'll see, it wasn't nothing, but not enough. Right? So it really makes a difference. One of the very first things you're going to want to be able to say is, when you see the indictment is, I got to get this. I don't want to just become acquitted. That's your best outcome. But if you can just say, the nature of the conspiracy is different than the government is alleging, you can get a pretty good outcome, or at least a better outcome, for your client. Okay? Caldwell says, look, I admit that I conspired with Herrera, but I did not, yes, it's Caldwell, not Anderson, under 100. But it could be either way, we don't care. Right? Caldwell says it was under 100. What was Caldwell's arrangement with Herrera? What was Caldwell's, Mr. Razor?
He was the street level dealer while Herrera was the supplier.
And he got about 2 to 7 kilograms of pot every few weeks. And if you add that up, and it has to be over 200 kilograms over a 2-year period, 2 to 7 every few weeks is going to be under 100 completely over a 2-year period. And he would then resell it to users, and Anderson was a friend of his and eventually became one of Herrera's main customers. Initially, Anderson had dealt drugs to Caldwell, but that relationship trailed off, and until early 2006, they had no additional drug-related interactions. Okay? So there was a relationship here, and the government wants to use that to say, hey, this is all one conspiracy. This is all one conspiracy. Is there any evidence of this other than what I just related, that Anderson had dealt drugs to Caldwell? There's a relationship. And they were friends. What else does the government have, if anything?
Caldwell was the one that introduced Herrera and Anderson and started that road.
And it was in response to Anderson asking whether Caldwell knew of a reliable supplier. So there's a connection that binds all of them together. What are the limits of that are important, as it turns out, to the 10th Circuit?
Caldwell argues they're more like competitors, not as much mutually beneficial relationship.
And in fact, he says, look, I don't get any economic benefit from anything that Anderson, I didn't get any benefit from them introducing Anderson and Herrera, because you can imagine, if you go back to Loria, remember we said, if you're getting an economic benefit, in that case, from the prostitutes using your service, that becomes a big part of the business, that can be an indicator that you are part of the conspiracy, okay? But he didn't get anything for that introduction. It was, as far as we can tell, done just as a friendly thing. And afterwards, he had no role in the Herrera-Anderson relationship. So those are some of the limits of how these three are interconnected that Caldwell relies on, okay? So what kind of conspiracy was this? One single conspiracy or two separate ones, based on all these facts?
Two separate ones.
I'm sorry?
Two separate ones.
Two separate ones. There was a Herrera-Caldwell and a Herrera-Anderson relationship. First, Caldwell and Anderson were not links in a vertical chain from Herrera. If Herrera had been the wholesaler and Caldwell had been the retailer and Anderson had been the customer, or if there had been if Caldwell had been a middleman and Anderson had been the retail street level person, all in a vertical conspiracy, then that would have been completely different. But that wasn't what we had here. That wasn't what we had here. What you look for, if it's a single conspiracy, is interdependence. That didn't exist here, right? Nothing in the success of Caldwell's efforts or business with Caldwell had any effect on Anderson. All they have is sharing a common supplier, and that is not enough. It could be part of the basis, right? It could be one fact you rely on, but it's not a sufficient basis. So I'm not saying it's irrelevant that Anderson and Caldwell share a common supplier. If I'm the prosecution, I'm certainly going to be able to use that, but it's not enough. Keep that difference in mind, the difference between something being irrelevant, because that's not irrelevant, and it being sufficient. It's relevant, but not sufficient. Okay? So they each had separate illicit businesses, each obtained marijuana and sold it to customers. And in a real sense, as Mr. Razor suggested, they were competitors rather than conspirators. Mr. Razor, one last question. What if they had had an agreement with Herrera and implicitly with each other, by which they would divide up territory with one another for each of them to distribute at the street level?
More of an interdependency.
Because?
They have a shared intent.
And what else does it show other than, or in addition to, interdependency?
They each have a stake in each other's ventures.
They might, yeah. What else?
So they had a further agreement, like they planned it out, and
And we know that the agreement does not have to be explicit.
Yeah.
So if they each agree to divide up territory with Herrera, then there's an implicit agreement with each other. Reinforcing this idea that conspiratorial agreements do not have to be explicit. So I think if you had that, which you don't, if you had that, very different case. And the conviction could be upheld as part of a single conspiracy where there would be over 100 kilograms. Okay, we'll stop there. And we will start with exculpation on Monday.